A very good afternoon to each one of you. On behalf of Bangalore Chamber of Industry and Commerce, we welcome you all for this exclusive session on point counterpoint analysis of implications of Supreme Court ruling on Tiger Global. On behalf of BCIC, we express our sincere thanks to Honorable Pramod Kumarji, Advocate and former Vice President, Income Tax Appellate Tribunal. Thank you very much, sir, for accepting our invitation to be part of this session. This session is organized under the aegis of the Direct Taxes Expert Committee, chaired by Mr. Sunil Dhareshwar, Executive Vice President, Taxation from Infosys, co-chaired by Mr. Sriram Ranganathan, who is the Vice President and Global Tax Head, Wipro Limited, and mentored by our past President and partner Deloitte and Mr. K.R. Shekhar. And thanks to all the participants for making it convenient to be part of this exclusive interaction. And I know BCIC acknowledge the support of its annual sponsors for their support in the activities of the chamber throughout the year. And thank you very much to all of you once again. And I request Mr. Sriram Ranganathan to take over from here. Over to you, sir.
Yeah, thank you, Rupa. And thanks everyone for joining. A special thanks to Pramod Kumar, sir, who's taken his time out. And sir has been very passionate about wanting to be part of this discussion. Thank you so much, sir, for your acceptance to participate in this. And Shekhar, thank you so much for pushing us to do this session. You've been a mentor who always pushed us to do more than better than the last time. So we have here at a very important juncture on international taxation, right? As we are aware, this Tiger Global judgment has come in the late January, and it has set a lot of precedences, right? The way judgment is brought in has raised a lot more questions, and who better than Mr. Shekhar and Pramod Kumar sir to give us their insights on how they see this judgment. So I'll start with you, Pramod Kumar sir. Tiger Global is it fair to say, as a taxpayer, as an industry, that Tiger Global has changed the way the treaty interpretations has been looked at in India?
Thank you so much, Sriram. Thanks for inviting me to be part of this important discussion. And it's a pleasure to be with you and Shekhar, two of my good friends. Now, when you talk about this decision as a kind of a landmark decision which has changed the way the treaties are to be interpreted henceforth, I would rather say that yes, it's an important decision, no doubt, but this decision is essentially on the grandfathering aspect. And as for the interpretation of tax treaties, there are two problems. One problem is that most of that part is in the courts of the arbiters. So I would say that's not the final word. Undoubtedly, whatever the Honorable Supreme Court says is always taken with deep respect and great reverence. But then one has to understand the legal part of this. Respect is one thing, and it's being binding in nature is another. So I think it's an important point where some issues have got identified, and there's a good deal of public debate about it also. The Honorable Supreme Court has made some interesting observations. But at the end of the day, the only question that their lordships decided was whether it was a fit case which should have been adjudicated upon by the AAR, or which has been rightly declined by the AAR to be adjudicated upon. That is the core question. And one important observation which they have made is that the circular 689 is no longer valid. I think barring these two important observations, when we think of what has been decided and the manner in which it has come up for discussion, and whether applying the inversion test, can it be considered to be ratio, I think answer will be negative. So while the judgment is important, it's not the end of the road. It's not the final word. And do remember that respect for the Honorable Supreme Court judgment is one thing, but it's a matter of course that law keeps developing. I mean, if you look at this morning's newspaper, I was looking at this morning's newspaper, I found two pieces of news in Times of India Delhi edition, one at the very first page and the other was at page 16. And both these decisions talked about referring the earlier decision to the larger bench. And one of these decisions is as recent as 2018 judgment in the case of Sabrimala, and it has been referred to a seven-judge bench. The other decision, very interestingly, which is what finds mention at page 16, is a decision on the definition of industry. And that's a definition in the case of a Bangalore concern. This is called Bangalore water supply case, where the legendary Justice, Justice Krishna Iyer had given the triple test. And Justice Krishna Iyer is one of the most respected judges in the Indian jurisprudence. But nevertheless, that decision is now being referred to a much larger bench for being considered everything afresh. Also remember the fact that when Justice Chandrachud became a judge, among the first few judgments which he passed way back in 2017, and the case was a case Puthuswamy case. And then he said something, and he made a concurring note where he mentioned it. He reversed a view taken by his late father, Justice Chandrachud, in the case of ADM Jabalpur. So law keeps evolving, and that doesn't mean that you don't have respect for the law. That doesn't mean anyone doesn't have respect for the precedents, but that's the way the law evolves. And therefore, while one should give all the due respect to the judgment, one also has to take it in its stride in the sense that it's a larger journey. It's not the end of the road.
Thank you, sir. Thank you for your opening remarks. Sir, you had referred to grandfathering a couple of times in your opening remarks. Would you want to dwell a little bit about the concepts around grandfathering? Because that's one of the very critical aspects that was looked at in this judgment.
I entirely agree. I think once we take a careful look at the grandfathering concept and understand its nuances, then the whole way of looking at this problem changes. Now, grandfathering in simple English is that let the old rule keep applying to the situations that already existed before the law change, while the new rules applies to the future cases. And that is to protect the acquired or vested rights and avoid retrospectivity in the amendment of law, harming those who have complied with the law as it stood at the relevant point of time. If you look at its legal definition, and I think we have this Black's Law Dictionary definition, it says grandfathering is an exception to a restriction that allows all those already doing something to continue doing it, even if the new restriction would stop them. Similarly, you have Cornwell Law School online dictionary saying, defining grandfathering as conduct that continues to receive the treatment of prior laws or rules under a grandfather clause even after its legal changes. So essentially, grandfathering is an interesting concept in the sense if you consider grandfathering on the touchstone of equity and fairness, it may not pass that test straight away. The reason is simple. I mean, it's for very practical reasons. It is to avoid disruption. It is to avoid disruption in the established practices. And it creates conflict with the principles of equity, that is fairness and equal benefits, because the same transaction gets treated in different manner because of the point of time when these are entered into. And let me also tell you that as long as grandfathering is constitutionally valid, then it is to be respected despite these inequities. And this is not something unique to tax laws. You will find it in all corners of life. As a matter of fact, it is a very interesting origin. The very term grandfathering is a very interesting origin. It has a US origin. In 1870, the 15th Amendment was made in the US Constitution, which said you cannot differentiate people on the ground of caste, creed, color, etc. Then there was a law in 1907. It was in 1870 or thereafter. The law was this. That was a point of time when you had lots of people of African origin who were coming to United States. Many of them were coming as slaves. And the local people did not want to give them right to vote. So they introduced a provision which said, you have to pass a basic test about the education. This is what they call literacy test. So if you don't pass the literacy test, you don't have a right to vote. But there was an exception. An exception was that if your grandfather had a right to vote, then you will be allowed this right nevertheless. The net effect of this amendment was that all these people who had come from the African continent, they had no right to vote because their grandfathers were not there. They were slaves or they were immigrants. Then, then there's a famous judgment of 1915. It's Gins versus United States. It was the 8-0 judgment of this Supreme Court, which said, no, this grandfathering is unconstitutional because you are doing something indirectly which is not to be permitted. And you are de facto discriminating against the locals, against the people of a particular community. Now, grandfathering had such an inglorious beginning, but it has been constantly accepted, not only in laws, not only in policies, even in constitution. It has been accepted because to give it some kind of order, to stop disruption, to ensure that people who are not affected, who followed the law at the point of time when law was there, they are not affected. In Indian Constitution, you have Article 20, sub-Article 1, which is the grandfathering clause. Today, if an amendment in law is made with respect to the penal provisions, it will only apply to the laws which are committed to the crimes which are committed after that date. Then you have grandfathering in law. And you can be different type of grandfathering. Take, for example, when Chartered Accountants Act came into existence. On 1st July 49, when CA Act came into existence, those who became initial members were not the...
Can you just...
They were not the members of...
I request all the people to go on mute. Rupa, can you mute everybody, Rupa, if you don't mind? Other than me, Pramod Kumar sir and Sriram.
Now, when I was talking about Chartered Accountants Act, for example, these people who became members, they were not the ones who passed examinations. They were not the ones who passed who did the internship. Yet they became members and they were given the same treatment. And I'll give you a very amusing example, which is very interesting. One judge, Justice Vanchu, who was 10th Chief Justice of India, he was an ICS officer of 1924 batch. And that was a time when ICS officers used to become judge. So when Indian Constitution came into force, he was already a judge of Calcutta, of Allahabad High Court. He had done his plain BA. He must be the only person who has not done in LLB, but he was given a doctorate in law. He not only continued to function as a judge after the independence, because under the grandfathering provision, those who were already appointed, they were not disturbed. He even went on to become the Chief Justice of India. He was chairman of the Vanchu Commission, which brought in major reforms. So the point I wanted to make was that grandfathering is not something equitable. If today a lawyer cannot become a judge, why should a person who became a judge prior to the Constitution coming into force continue to remain a judge? But it is accepted. It's accepted as a policy. Then it's accepted as conduct. I will give you a very recent example. In IT80, the Tribunal Reforms Act is struck down by the court. But the people appointed under the Tribunal Reforms Act continue to be members. That's a kind of grandfathering. It's a grandfathering by conduct. So you have the grandfathering by constitution, and you have the grandfathering by legislative provision. You have the grandfathering by executive actions. For example, this grandfathering under Rule 10U, that's a grandfathering by executive action. This is not a part of the statute. The grandfathering under the tax treaties. And these grandfathers, if you look at a judicial lens, would sometimes seem to be inequitable. They would seem to be unfair. What difference does it make whether I made the investment on 30th March or on 10th April? I should be given the same treatment, but no. The system of grandfathering ensures that disruption will not be caused to a person who had followed the law. So once you understand the concept of grandfathering and the inequity, if I can say so, built in that, then you tend to be little more liberal to the reason and rationale why grandfathering is introduced. That was the context in which I thought of grandfathering.
Sure. Thank you. That's a very comprehensive, not just the tax law and Indian context, a global context, how grandfathering has been looked at, right? Shikhar, I would want to turn to you. You've been an expert in international taxation for more than 4 decades now. You've authored many books specifically on how DTAAs work, the interplay between the domestic law and the DTAA. How do you look at this judgment in the context? Has the jurisprudence on treaty interpretation changed once and for all, or is there any hope left for the taxpayer, Shikhar?
Okay, thanks, Sriram, and thank you, sir. for coming over to the BCIC webcast. So ever since the judgment came, Sriram, me and Pramod Kumar sir was almost speaking on everyday basis. I never thought I would spoke with Pramod Kumar so much before Tiger Global ruling, except we used to at least speak and exchange thoughts.
At least we can see some silver lining in Tiger Global.
Yeah, thanks to Tiger Global ruling, me and Pramod Kumar, at least every day we started speaking. The challenge for me, Sriram, it's not about the ruling is in favor of the taxpayer or is in favor of the revenue. I'm not worried about to whom favor it is. But the process and the reasoning given by the Supreme Court is what I'm unable to fathom it. I'm unable to digest it. With highest sense of humility at my disposal and with due highest respect to the lordships and Supreme Court, the judgment suffers from inaccuracies in multiple places. So the judgment has got multiple inaccuracies. I'm not sure whether anybody can quote this judgment for any valid principle. That's my first on this judgment. I'll come to my interpretation of treaties and double check a little bit later, but I just want to put that my initial thoughts. Second, the process what the Supreme Court said, tax residence certificate is not valid. Mauritius income tax TSA we will not accept as a valid document. You need to have a substance test in Mauritius. 4, that entire circular was issued in before the amendment of 90 subsection 4 and chapter 10A. There are subsequent amendments that come. Therefore, the circular issued before that is not valid. Azadi Bacholan was held in a different context. That is not valid. And Vodafone conveniently ignored on one way or the other. For me, more than the validity of the judgment, this judgment opens up multiple complexity issues in the judicial propriety. The first one, what the Supreme Court says is that there are subsequent amendments in section 90 subsection 4 and what they call part 9 and 9A and part 10, which makes the circular invalid. What are the amendments that has come? 90 subsection 4, which nothing but reiterates the concept given by the circular. And there's another subsection 90, which says that if any other information, any other thing is required, the authorities will look into it. What is 10A? GAR. How can a GAR and the 90 subsection 4 amendment be a substantive amendment to say that the circular is inapplicable? If you want to hang companies coming into Mauritius, you hang them, but give a proper reasoning to hang them. Don't say that circular is issued and has been overridden by the amendment. There's no substantive amendment to override a circular. Therefore, tomorrow, if any CBDT circular is coming up, and tomorrow Supreme Court wants to overcome the circular, they can use this as a precedent. My worry is that. That's the first one. The second one, more important issue. Azadi Bacholan is a 2-member judgment. Azadi Bacholan is not a judgment given by the Supreme Court on the plea of a taxpayer. It is a judgment based upon the PIL filed by one NGO. And the government defended the Mauritius Treaty and the circular before the Supreme Court. Now the same government, same ASG, not same ASG, another ASG, representing the government says that the treaty is not valid, the circular is not valid. What has happened between Azadi Bacholan and today? Nothing, except for the fact that there's a minor amendments came in the Income Tax Act. The third important disturbing for me this judgment. Take Vodafone. Somewhere I read, though Supreme Court in this judgment has not dealt detail why they are not following the Vodafone judgment. It reproduces the entire Vodafone judgment in selective paras. Now to say Vodafone judgment you cannot follow, so Vodafone is a 3-member judgment. A 2-member judgment, if he has to overcome the 3-member judgment under the Supreme Court established procedures, the judgment should be an arbiter dicta. It has got a persuasive value. It's not a ratio descending. Now, to nowhere I see in Supreme Court judgment that Vodafone is an arbiter dicta, not a ratio. Nowhere the Supreme Court has analyzed it. And I heard in somewhere in the private conversations, Vodafone is not applicable because it is given for a Mauritius treaty. I'm sorry, it is not for Mauritius treaty. The fact of Vodafone is not on Mauritius. Therefore, the Supreme Court judges are constrained to apply the Vodafone principle, which I'm, with due respect to person whomsoever is talking about that, I humbly submit to disagree with that. What is a ratio descendi and what is a arbiter dicta has been decided by Supreme Court in Vaman Rao judgment, which is quoted in HMC White Book. I wrote in my part 2 of the Tax Sutra article, HMC makes it very, very clear for the benefit of the readers. I'll read it across. This must be for different judges may have different philosophical attitudes, concept, ideas, and ideals. And if judges disregard judgments binding on them in order to give play to their own attitudes, concepts, ideas, and ideas, the result can only be judicial chaos. And that is what is happening. You completely ignored Vodafone, 3-member judgment, and you come out with a new reason that is not valid. What is the other point that Supreme Court has put in across? If a taxpayer has to claim the treaty benefit, the taxpayer must have paid the tax in the other country in order to claim a treaty benefit. In my view, it is completely what I would call an error by their lordships with highest respect. The liability tax and subject to tax has been completely settled. Now, where is the question of bringing out a new concept? If this is a new concept, then what is the implication of section 90 subsection 2? 90 subsection 2 makes it very, very clear the tax or treaty, whichever is more beneficial. Now you take your logical extension. UAE doesn't impose tax for the individuals. Can you say that the individuals are not eligible for any treaty benefit with India? Where are we taking it across? So on the whole, I'll still come to my favorite topic of indirect transfer and various other topics. But on the overall one, to my mind, the basis on which this Supreme Court judgment has come, the foundation on which the Supreme Court judgment has come, can be questioned by multiple authorities. And in my view, if a Supreme Court judgment gets debated like this on principles, then it is not good. You can debate about the judgment, the conclusion, but the principles on which the Supreme Court judgment has come, if that principle gets debated, then it is not a good practice in the country. And that is what I'm worried about it. And the last but not the least, you asked about the interpretation issues. India never practices the concept like Europe and other places where the treaty gets into part of the domestic tax law. India practices the concept of 90 subsection 2, whichever is more beneficial. Now, if you go to the judgment says somewhere they talked about the treaty interpretation and brings out a new concept that the treaty has to be read with domestic tax law. And that is what is more disturbing for me, the entire basis on which it has come. Yes, to my mind, this judgment opens up the different issues. Probably we'll ask when you come to subsequent questions, I can answer it. It opens up multiple issues. But to my mind, the basis on which the edifice on which the judgment is built, that edifice is incorrect. You want to tax the Mauritius companies? Tell them, withdraw the circular. But you cannot bring an incorrect principle to tide over the temporary issues. That is my point, Surya. I just pass over here.
One quick comment, if you permit,
please go ahead.
I'll just take 3 minutes. First of all, I wouldn't really say that whether Supreme Court is right or Supreme Court is wrong. I would just be, more interested in doing a clinical analysis, because the moment we say this is wrong, this is right, then we get into very emotional stuff. And there are some people in the debate who can be extremely emotional about these things. So let's keep that aside. We are just putting a perspective. It's for others to take a call. What could be right? What could be wrong? Now, the first point that Mr. Sekhar made regarding circulars. Now let's take a clinical look. When do circulars cease to hold good in law? Forget about the circulars issued under 1961 Act. Let's look at circulars issued under 1922 Act. Do they still hold good in law? I would think yes.
Yes.
And even the circular issued under 1961 Act, they will also hold good in 2025 Act. If you look at what is the test, and that test is given in the transitional provisions. There's a section which gets referred to very rarely, This is called section 297(2)(k). And I'll just read it for you. It says, notwithstanding the repeal of the Indian income tax so and so, any agreement entered into, appointment made, approval given, recognition granted, direction, instruction, notification, order or rule issued under any provisions of the repealed act, so far as not inconsistent with the corresponding provisions of this act, shall be deemed to have been entered into, etc., etc. Now the test is when it becomes inconsistent with the provisions of the act. Now what makes it inconsistent? According to the judgment and according to the arguments which were given there, 4 factors. Factor number 1, insertion of subsection 2A to section 90. What does section 90, the 2A talk about? It says, notwithstanding anything, the provisions contained in chapter 11 shall apply to this, even if apply to this situation, even if they are not more beneficial to the treaty. Now, when you are talking about chapter 11, that is GAR. The amendment was made in 2012, but till 2017 there was nothing. And when GAR came, there were corresponding provisions. And remember, it was exclusively for GAR, not for every anti-abuse law. There's a difference. As Shekhar very rightly pointed out, there are different models. In US, for example, you pass any federal law which is at par with the treaty, it can override the treaty. That doesn't happen in India. Now, nobody has gone into the question, where does it become inconsistent with that? You talk about 94, 95, they talk about it that this requirement is not sufficient, but how does it become in conflict? No one knows about it. Then you talk of explanation 4 and 5. But for God's sake, don't forget that explanation 4 and 5 are something which do not affect the tax treaties. That's what the Indian finance minister said on the floor of the House. And I'll just read what exactly was said on 7 May 2012. I would like to confirm that these clarificatory amendments, that is explanation 4.5, do not override the provisions of the DTAA, which India has with 82 countries. It would impact those cases whose transactions are routed through low tax or no tax countries with whom India does not have a double taxation avoidance agreement. So explanation 4.5 do not come into picture. In any case, because of the explanation 4.5, you did not change the definition. What is left? How does it become inconsistent? Is one thing which, according to one school of thought, will not be probably compatible with that approach. I wouldn't say right or wrong. Then you talk about payment of taxes in one country being a condition precedent to avail tax treaty benefits in the other. Some people have referred to section 229A. When did this section come into existence? 1st April 2021. And you are looking at a case where the AR judgment came in 2020. So the entire, the entire foundation is something where alternate approach seems to be equally, if not more, sound. And anti-abuse law, this is one theory which is repeatedly given in the judgment, in the arguments, in the webinars. Because of subsection 2A, it is not that any anti-abuse law can override the tax treaties. Only the provisions contained in chapter 11. And these provisions are general anti-avoidance rules. So I agree with Shekhar that on all the 3 fundamental counts, the alternative approach to this issue seems to be far more conceptually attractive. But then I take comfort in the fact that these are in the nature of obiter. And one advantage from the taxpayer's perspective is that the matter has to travel. It is, the matter has not reached finality. The matter has to travel again, in the judicial process. And don't forget that in earlier cases, take for example, the virtual soft system. Virtual soft system judgment came on 6th February 2007. Before August 2008, that judgment was reversed by a larger bench. Take McDowell's case, 1984, 5-judge bench, which is so much talked about case. 1976, this issue in SSC's own case was in favor. Similarly, take Merlin shipping controversy, paid and payable controversy. We saw how it developed. So this is the legal battle is still on. An alternative proposition is still there, and I'm entirely with Shekhar so far as the conceptual foundation of these 3 points which he made, and I wholeheartedly, support his point on saying on conceptual part. But having been in the government for 23 years, after 43 years, I've had post-qualification experience. I tend to be a little more skeptical about saying who's right, who's wrong. I'll say in the long run, this too shall pass. Thank you.
Sriram, the one more important point, just before you ask me the next question, I just want to add what Mr. Pramod Kumar said. If anti-avoidance, McDowell principle has been largely diluted after Vodafone, after Azadi Bachodan. Now, where is the McDowell giving a rebirth in this? And you can say McDowell because I'm coming through the Mauritius entity. That's a McDowell principle. I'm unable, because the same Supreme Court in para 368 of Vodafone judgment has been reproduced in the same ruling, where it says Vodafone says that GAR will apply if I'm interposing an entity only before the transfer, and therefore anti-avoidance regulation would apply. Now, this entity has been existing for the last 10 years. The other beautiful point which Mr. Pramod Kumar said, I'm just trying to get my fundamental what I would call inability to accept certain principles of this judgment. Mr. Pramod Kumar said about grandfathering. What is grandfathering? 2015 Shom Committee said, because fortunately at that point of time from Deloitte and me along with some other senior partners represent before the Shom Committee on what is grandfathering. What is the purpose of Shom Committee? The investments, what are the structure that you are given, that will give the grandfathering, so that those investments subsequently when you make an alienation or transfer, you are not subject to tax. Now you are saying the Supreme Court says that the investment is grandfather, not an arrangement. The arrangement comes after 31st March 18 because you made an entry into an agreement. How can there be a difference in this from the structure which is grandfather? Where is a grandfather without a grandchild? So I'm unable to accept the base principles on which the judgment has come. That's all my limited point, Sriram. Go ahead with other questions, Sriram.
Yeah.
Go ahead, Sriram.
But Shikhar, with this judgment now out there, is it right to assume that the principles settled in Azadi and Vodafone are no longer relevant? Is it fair to say they have been nullified?
I would not say no longer relevant, Sriram. Let me be, this is purely my view. I'm not a constitutional expert, but purely my view. The law has been evolving in India over a period of time. I thought the law got settled after Vodafone. That was my honest. Not only me, most of the tax professionals believed that after Vodafone, the law got settled, except through the GAR. But now today, this judgment reopens the entire Vodafone judgment on a principle, to my mind, which I'm unable to accept it. Now, there are two ways to look at this judgment. Number one, or multiple ways. I'm just putting two ways, but on a multiple ways. Number one, still, is there any way, which me and Pramod Kumar very often we discuss, is there any way by which we can narrow down these principles of this judgment to a binding nature of this, narrow down the principles of binding nature? Is there any way we need to do that? That's the first one. The second one is that from a taxpayer perspective, the risk is pretty high, because to my mind, the authorities can use this judgment for anything that comes. Even if you take a lease versus ownership, they'll say, boss, it's an anti-avoidance, I will go into it. The third issue is that this judgment says that India-Mauritius Treaty, indirect transfer is not eligible for India-Mauritius Treaty, which is something I'm unable to accept it, because the same judgment they read, as Pramod Kumar read, the finance minister's speech, and Honorable Finance Minister's speech is considered as an accepted rule of interpretation of law based upon Supreme Court and Builders Association of India. Quite a lot of judgments are there. Now, when Supreme Court uses the Finance Minister's speech, now on what context you say that Mauritius Treaty is not applicable for indirect transfer? Because of TRC, because of substance test, because of anti-avoidance regulation. Now, with the same principle, the authorities can invoke this for other treaties. That is my other challenges. Therefore, it is incumbent on part of organizations, chambers of commerce like us, and professionals like us to represent that the judgment has got a severe implications on a practical. So leave the legal interpretations aside, which will come to later. For example, you are a listed company. There are a lot of listed companies like you, where you have got a shareholders from Mauritius. Now, if you say, boss, TRC is not applicable, TRC is not eligible, how will you deduct tax dividends? Today, it's not even a distributed tax. You have to deduct taxes. So will you go back on the TRC and get it everything? And that's another philosophy that is coming up, which is something which I go back to the base principle. Fortunately, it's not coming in the Supreme Court, but again, some sort of eloquence is going about it. This circular is not applicable only for FIAs. It's not applicable for any other taxpayers in Mauritius. To my mind, I'm unable to accept the principle because what the circular is lays down the principle of test of residency for Mauritius. The circular clearly mentions in a particular paragraph that tax residency certificate. In fact, I read out that particular paragraph from the circular. It's a very important one. Yes, sir. Para 3. The test of residence mentioned above would also apply in respect of income from... No, I'll go to para 2, sir. Prior to 1491, dividend distributed by domestic companies were taxable in the hands of the shareholders and tax was deductible at source under the Income Tax Act 1961. Under the DTAC, tax was deductible at source on the gross dividends paid at the rate of 5% or 15% depending on the extent of withholding if the Mauritius resident of the Mauritius resident. Under the Income Tax Act 1961, tax was deductible at source at the rate specified under section 115A, etc. Double tax doubts have been raised regarding the taxation of dividends in the hands of investors from Mauritius. It is hereby clarified that whenever a certificate of residence is issued by Mauritius authorities, and certificate will constitute a sufficient evidence for accepting the status of residence as well as beneficial ownership for applying the DTAC accordingly. Paragraph 2 makes it very, very clear that it is a circular, the test of residency is final. Now, somewhere that the circular has been given bypass. Now, Mr. Pramod Kumar quoted about the 1922 circular, 1961 circular. That's a circular which was issued by Central Board of Revenue 1965. What that 1965 circular says that circular wherever, even if the taxpayer has not claimed any benefit on that circular, on the provisions of the law, if the taxpayer has omitted to claim any benefit, and if there are benefits bestowed to the taxpayer under the law, it is a duty of the assessing officer to give the benefits to the taxpayer. Now I have a circular and on some pretext or the other, you say circular is not applicable. Now, problem arises, Sriram. If the Supreme Court judgment principles are going to be applied on a day-to-day basis, it will create litigation. And therefore, the first thing that we as a professionals and we as a, from my chamber of perspective, and also we are talking, as you know, to the various authorities in the Ministry of Finance, that we should narrow down the principles of the Supreme Court judgment on various matters. Second, I am not so sure whether any review petition can be whether the Supreme Court will, anybody will apply a review petition with the Supreme Court, and whether the Supreme Court will accept a review petition, because going by the past, the review petitions on the tax has not been successful. But there are cases which Mr. Pramod Kumar started saying at Sabarimala case and other cases where the government accepted the review petition. Supreme Court accepted the review petition, but it is important to show down the review petition that it is not a mistake, but there are some contrast and conflicts in the judgment which has put the issues around the principle. Somewhere we need to bring that so that it gets legally sanctified. And last important thing, Sriram, is that while I saw somewhere in the press where they are not going to reopen the assessments based upon this judgment, I'm happy, but there must be a more clarification on that, because if there is no clarification, nobody is going to follow the press release. There must be absolute circular from the board that they are not going to reopen it, and they are not going to apply this principle on generic basis across all the taxpayers. So these are all the things that needs to be done. If these are things not done, then what you said is right. Vodafone as well as Azadi Bachchan will be given a sufficient override by the state.
One small point I must add on this also. In this circular, in paragraph 3, it says the test of residence mentioned above would apply in respect of the income from capital gains on sale of shares also. The next sentence is interesting. Accordingly, FFIs, etc., which are resident, etc. Now, based on this mention of FIIs, what has been discussed in the courtroom is that this circular applied only for FII. It is not that the circular is applied for FII, it is because the principle is laid down, because of which principle FFI comes into play. So, as a matter of fact, to suggest that this circular remains confined to FFI, I think that is an approach or an interpretation which certainly admits an alternative interpretation which seems more convincing. That's one. The second point is this: what is the point of time when circular cease to hold good? How does it become, come in conflict? Conflict is one thing, harmony is another. Something may not be in harmony, but it may not be in conflict. Now, unless it's in conflict, doesn't come into play. That was second point. Finally, in this judgment itself, their lordship refer to KP Varghese case, and they say benevolent circulars are binding. They accept that position, but when it comes to corollaries, they say no, it doesn't hold good because here's a case, the law has changed. So I think these are the fit cases which I'm sure could be discussed in more detail in the cases to come. Thank you.
Yeah, thanks. Thank you. Thanks for that, sir. So one of the other observations or arguments in this case has been that Rule 10U2 emasculates and eclipses 10U1D. What's your view on that, Pramod Kumar, sir?
I think that's the most, I would say, interesting part. I wouldn't even say interesting part because that sometimes seems to be very strange interpretation. Now, the words in 10U2 start are without prejudice to the provisions of so and so. So when you say without prejudice to, it means keeping that thing intact. If you say that I have made provisions of 10U2 which are without prejudice to 10U1D to be precise, in simple English, it means irrespective of these provisions, 10U1D will remain intact. So there cannot be a situation in which 10U2 could emasculate or eclipse 10U1D. That's an antithesis. It has to protect 10U1D. I was wondering how to, hammer that point or, try to make it more clear. I tried to look at Hindi dictionary, at a Hindi text of the income tax rules. And that interesting observation, they have bina pratikul prabhav, without adverse effect. So there is no way in which 10U2 can emasculate or eclipse or dilute or narrow down the scope of 10U1D. So assuming for a minute, hypothetically, that the meaning of investment and meaning of arrangement could be different, which it is not. Even then, when you are looking at the non-grandfathering of the arrangement, you have to do it in such a manner that 10U1D is not eclipsed. It is not emasculated. It is not narrowed down. It is not diluted. To my mind, whatever we call it naivety or whatever, to my mind, it's a simple case of error where the words without prejudice have been read as diluting the other provisions. This is more like notwithstanding. So I cannot imagine a situation in which you have a without prejudice clause in a particular provision and it dilutes the very provision without prejudice to which it is formed, it is enacted. I tried to look in several decided cases. So there were two ways in which they have interpreted it without prejudice. One is, of course, privileged. This is the communication. Otherwise, they have said this remains intact. This remains uninfluenced. So that's a ground on which I think the view expressed by Honorable Supreme Court seems to be, maybe because of my being so naive or my not being able to understand that nuance, seems to be quite contrary to what the plain, simple legal position is. You don't need a legal book to understand that. Even a dictionary would help. I cannot visualize this situation. I think that's the point where a review or some kind of a reconstruction is required. But then the reason why I'm worried is because it's being discussed again and again. This judgment, after the judgment is rendered, more is said in the defense of the judgment rather than in the judgment itself. So I don't want to get into that kind of a debate. They have their point of view. I have my point of view. Let's leave it to somebody else to judge. Or maybe in the times to come, that will be put to test.
Sriram, the one other point, Sriram, taking it forward from what Mr. Pramod Kumar said. When I read the Supreme Court judgment, the way I got the impression was that they're given the meaning without prejudice, an equivalent meaning of notwithstanding, a non-obstante clause. Without prejudice is not equivalent of a non-obstante clause. Without prejudice is that the right contained in the second clause is not impacted by the right in the first clause. That's all. Does not mean that the second clause overrides the first clause. Without prejudice has got no meaning. It's not synonym with notwithstanding. And that is my another challenges in the judgment, because they equated without prejudice to the notwithstanding term. And number two, more important fundamental rule of interpretation, without prejudice is coming in the part of the rules. The rules are subservient to the provisions of the Act. A rule cannot have a meaning which is overriding the provisions of the Act. Now, if I apply this particular principle, the entire provisions of the McGar arrangement gets overridden. To that extent, I have a challenge. The third important aspect, which will come down anti-avoidance regulation, Supreme Court has touched upon it. Now, when I apply all these things together, once again, it is a case where, as I said, I am not worried about favor of taxpayer or revenue. What I'm worried is the process and the base on which the judgment is being given. Does this process and the logic can stand the test of the law, test of scrutiny over a period of time? For example, I am a great follower of Keshavananda Bharati judgment, a phenomenal judgment. Keshavananda Bharati judgment still holds good for ages unless the constitution gets changed. When Supreme Court, when the review petition came, both in Keshavananda Bharati review as well as in Minerva Mills Limited judgment, H.R. Khanna made an observation. It was not Nani Palkiwala who argued, it was divinity who argued through Nani Palkiwala. So I do not know whether we need one more divinity to argue this matter, but my base principles on which the judgment gets standard is matter of huge debates.
Shekhar, one small point I would supplement. When you
Yes,
said
sir.
It's something done by the policymakers. Now, please understand, both the grandfathering provision that we are dealing with in this case are policymaker based grandfathering.
Absolutely.
Now, when a policymaker takes a call on grandfathering, because rules are, after all, 10U is enacted by the tax administration. It is not something which is part of the statute. Now, this is based on the doctrine of legitimate expectations on how this will be read. So as a matter of fact, I for one believe that the solution to this crisis, if you call it crisis, I don't know, I'm out of the picture now, retired man, enjoying my post-retirement life, doing a little bit of work and these academic things, then this solution must come from the policymakers. Because today you have a policymakers grandfathering assurance, which has been introduced by them. Rule 10U is not enacted is not law enacted by Parliament. Now they have to, clarify as to what did they mean, and whatever they meant has to be based on general expectation. And another problem which happens because of this policymaker perspective is that when you are interpreting grandfathering provision as if you are interpreting the text of the enactment, then the very orientation towards it changes. An executive grandfathering assurance is interpreted on the basis of legitimate expectation. An enactment having grandfathering provision is based on the principles of interpretation. And that's where I think the problem has arisen, because when their lordship see this, they see it from the judicial lens. They see it from the judicial lens of what is right, what is wrong, what is inequitable, what is equitable. And undoubtedly, grandfathering itself is inequitable. So I don't blame the honorable judges. My point is, here is something which should not have gone to them. If there is an issue about what does it mean, That's an issue to be resolved by tax administration.
Right.
And that's where the fundamental paradigm issue changes.
Yes,
No, thank you for that detailed view, sir. Now, see, one we have looked at the judgment, Shekhar, right? Now, this judgment is there and it has become law of the land now. Now, looking forward, right? See, there are capital transactions, capital gains, like in the case of Tiger Global, where you have a lot of assessments to be made. One can look at substance over form, etc. Right? But on a normal day-to-day trade, TRCs have and TNF have been accepted as a basic documents on which the benefits of tax treaties have been can be passed down. Right? Now, with TRCs being questioned as the basis to give tax treaties in a normal business payment, it could be royalty payments, it could be fees for technical service, it could be anything else. Like you had mentioned, it could be a dividend on a listed entity, right? What are the taxpayers expected to do to pass on the benefits? Because in and oftentimes these are with parties who are not who are non-AEs. These are third parties, right? And you wouldn't even have a wherewithal to ask them where is the origin, where is the decision making happening, is it happening in Mauritius, etc. with unrelated party. It is practically not possible. So what are the expectations from the taxpayers as to how has the world changed for a taxpayer after this judgment?
Very good question, Sriram. I would like to divide my answer into two buckets. One as a tax professional, one as a typical tax consultant. Let me give my answers in two buckets. Now, as I said, this judgment has opened up the lot of Pandora's box. Let's say for a minute, Sriram, forget about Mauritius. There is a UAE shareholder. You are giving a benefit of India-UAE treaty on various matters, whether it is dividend or anything, individual shareholder. There's no tax paid the individual shareholder in UAE because of the domestic law. Now, can you deny treaty benefit because of this? What is your responsibility? Second, Netherlands transaction. India-Netherlands treaty says that if the shares of an Indian company is transferred by one resident to another, shares of an Indian entity is transferred by one non-resident to another non-resident, it is not taxable in India. Now, under Netherlands, we all know that there's no capital gains tax in Netherlands.
Yeah.
Now, can Indian authority says this, boss, there's no tax paid in Netherlands, therefore I will not give the treaty benefit to you. Then third, you take a Singapore. You take the tax benefit of Singapore treaty on grandfathering itself. Singapore treaty, you have an LOB clause. Now, can the authorities say that, boss, you are not paid tax in Singapore, therefore you are not eligible for tax treaty benefit? The authorities can say, because there's one paragraph, it says that the paragraph is good enough to take a litigation to the highest level. And therefore, the first principle that should come from a tax policy makers, which Mr. Pramod Kumar said that, which you and I are fortunately working. I hope Ministry of Finance listens to it. We should not go to the CB, we should go to the Ministry of Finance. Somewhere narrow down the principles of Tiger Global to that extent. That's number one. Second, while thanks to Supreme Court, the 789 circular has been now buried and dead. Now you cannot give a life to the circular. Even for FIS, I do not know. Now, therefore, it is important for the government to issue a clarification how a Tiger Global judgment should be read in line with the circular and what is the result that government should come out. And that is where we need to work, Sriram, from a chamber perspective. Now, when it comes to the taxpayer perspective, you are responsible for withholding tax at source. Probably, I would say that you need to get an indemnity from the shareholder and the taxpayer person who is receiving the payment. In case if there is any defaults, you need to be protected. You need to get an indemnity. Otherwise, you need to go through all the documentation, get into the substance and form of the test. You have to go to the Mauritius company, whether the company is managed in Mauritius. What is the test of substance? Because in this judgment, they merely said that they reproduced the paragraphs of AAR ruling, and they said that we agree with the AAR that the company is not managed out of Mauritius, merely because one for US shareholder takes signs a check for a certain amount. And the fact remains that in the AAR judgment, it says that the Mauritius company conducts all its board meetings. These people are attending the board meetings. Now, the head and brain test is only board as per a settled principle. Now, the third point that arises, which is for me an extra territorial, some country recognize my law is like this. My country corporate law permits me to do this. My country law allows me to do this. And therefore, I am giving a certificate to you accept it. You are going and saying, but we were not going to accept it. You are disputing the entire provisions of that country legislation itself. So, unfortunately, Supreme Court in this judgment has not gone into the head and brain test, which is not required in my view. But still, they are not gone into that. They just went by the TRC and closed it across. So to that extent, there's no clarity for any of the taxpayers on what is a head and brain test, except you need to go to Radharani Holdings and other judgment. But point remains, suffice to say that as a taxpayer, as a person who is responsible for withholding of tax, your responsibility is numerous. Therefore, you need to get more convincing answers from the person who is receiving their payment on the benefit of the treaty. And more important aspect that comes in Sriram is the GAR provision. Now, what the Supreme Court has said that here, it is an anti-avoidance. What is the anti-avoidance? You have come through a Mauritius, you are not paying tax in other country. Therefore, it's an anti-avoidance. Now, at GAR law, you have got 8 tainted tests is there. You need to satisfy all the 8 tainted tests. And one of the 8 tainted tests is not satisfied. It has not even gone. Now, the point is that can a Supreme Court, based on the AR facts, can it come to a concluding that it's a prima facie, it is anti-avoidance? What is the definition of prima facie? Mr. Pramod Kumar will agree with me. Those days in 143 1A, I don't know how many people are born when 143 1A was introduced. 143 1A had a very peculiar word called prima facie, inadmissible, then the taxpayer will have to pay 20% additional tax. The prima facie, what Supreme Court said in Shriram Fibers case is that on the face of it, that's a smell test. If it is a smell test, then it is fine, then it's prima facie. Here you have not even done a smell test, you have not even looked at it. But Supreme Court came to a conclusion that it is a prima facie based upon the AR observation. To that extent, my GAR provisions also gets open. So the point is that Sriram, as the person who is responsible for deduction of tax at source, your responsibility becomes onerous, and to that extent, your documentation will have to be much more secure, Sriram. I just pass over here. Probably we can hear from Mr. Pramod Kumar on these points also.
But Shekhar, so far as the prima facie test is concerned, Justice Mahadevan has spent time. In fact, he devoted 2 full pages discussing what prima facie test. So I don't think that's in doubt. And one
no, my point isn't limited, sir. My point is limited. While he has dealt on prima facie, but whether this transaction is prima facie inadmissible under the GAR is a more important. That on a factual pattern, he cannot come to a conclusion.
If you look at the second last paragraph of Justice Mahadevan's order, the short question is whether the AAR was justified in rejecting the petition or not. And he said, yes, they were justified. That's what the ratio is. I mean, I wouldn't see it beyond that. Even when it comes to the TRC being sufficient for the purpose of establishing residence, I think the law, as I knew until I read the Tiger Global judgment, was entirely different. The circular held good. There were only 4 ways in which a circular could, cease to be enforceable in law, and none of those 4 ways was followed here. So that's
my limited point. When you come to a conclusion of the prima facie, from prima facie to impermissible arrangement, that path is completely missed out. Based upon the entire Supreme Court reasoning was based upon the fact it is TRC, it is a Mauritius entity. Is it a sufficient reason to hold the prima facie inadmissible arrangement?
You see, Justice, there's one judgment which which gets talked about many times, Sun Engineering. Yeah. Justice Anand's judgment. Yes, if you read that judgment, one interesting observation which Justice Anand has made therein is that whatever a judge says, he says in the context of the case that he is dealing with. Now, don't take it out of that case and apply it as if it's independent law. An observation of the judge is not something like a provision of law. It must remain within those things.
It was said by even Justice Y.B. Chandrachud in Minerva Mills, not in some other judgment is said the judges are also even they are also infallible sometimes when they go in interpretation. He said that.
Justice Cardozo, one of the most talked about judge, and he was Chief Justice of America, Cardozo, and he has written a beautiful book, The Nature of Judicial Process, which is available online free of cost. You read that book and then he expresses his dilemma. He says, every day I read my own judgments next morning and I say, my God, how could I do that? So he said, people have more faith in dicta than I have in my own judgments. So we have to be a little realistic.
Yes, sir. Yes, sir.
Yeah. So, sir, if you look at in the last 1 year, right, we had judgment on MF MFN that came about a year back. Now we have this judgment that has come in last month. So this question I would request Pramod sir to react, and then Shekhar, I'll pick it up with you. Is, sir, how is the international tax community looking at it, Pramod sir? You are well averse with, well, you read across international jurisdictions. What do you what is your view on how is the international tax community looking at this, especially when it comes to kind of interpretations around tax treaties?
That's a very difficult question to answer diplomatically. There are some articles. One came from Robert Golding, who's a well-known commentator in America. He wrote an article which was quite critical, and much more than being critical, the choice of words was less than appropriate. So let's not glorify that word by referring to it. But yes, there are on some occasions, there are concerns which are expressed about the judgments being slightly at variance with the first principles. But I don't really bother much about it. I mean, because most of the time people from capital exporting countries tend to have a perspective which is more aligned to their interests. And particularly when an American talks about the importance of your commitment to the international community, you take it with even more pinch of salt, for some time. And some, please forgive me for saying so, but I seriously believe, I rather suspect that one of the factors which have affected their judgment, particularly the doctrine of sovereignty part, it may have something to do with the way some people were behaving in the international arena, protecting their own rights so fiercely that they will throw the commitment to the international community at wind, and everybody had to be, defend his own interests. So let's keep that aside. One thing is sure, that the judgments are quite at variance, increasingly in many cases, with what is known to be right on the first principles. Now that's a phenomenon which is not, I would say, new to the Indian jurisprudence. You remember the judgment when it came in the case of Kulangan Chetiyar way back in 2004 or 2005, when the exemption regime, the credit regime was turned upside down by a judgment, and the tax administration had to make amendments in law to come out of it gracefully. So these things do happen, and that's not without reason, because the reason is that the honorable judges are experts in their own field. But when it comes to international taxation, they are heavily dependent on the quality of assistance given to them and the materials that they had referred to. The first time I read a treaty, although I qualified 43 years ago, for 32 years I'm dealing with international tax, and every time I read it, it's like, reading something new. Then how do you expect someone who has a time of 3 days, 4 days, 5 days, 10 days, and he has 1,000 other things to bother about, all nuances of law, to be so conversant with the nuances? That does happen. It's nothing new. But my worry is that if this trend continues, then people will tend to clog the MAP process. More and more people might see sense in invoking mutual agreement procedure. And that's where, again, policymaker will have a great role to play. So if the judgments continue on the lines, particularly these 2-3 judgments, one on the MFN, and the second is this one, the one we are talking about, and not the judgment really, some of the observations in this judgment, then there could be more undue pressure on the MAP, which is a cause of concern, and which happens generally in least developed countries or in the developing countries where judicial system is not strong enough. I don't care whether the cases are the judgments are in favor or judgment in against. I'm like a gynecologist. Whether son is born or daughter is born, that's your problem. Child is born healthy, fine. But when the judgments seek to challenge the fundamental principles, then one of the things which I think we need to talk about is the mechanics of Article 13. Where does it fall in direct transfers? Then there is definitely a problem with respect to the acceptability of the domestic dispute redressal mechanism as a dispute redressal mechanism for the foreigners, which could be a cause of concern, particularly given the very limited resources we have for MAP. I don't know what Shekhar's take. How many people talk to you about going to MAP?
I'll just complete few my comments. So Sriram, you raised a most favored nation clause and other matters. probably I don't know how many of you are aware, the first most favored nation clause judgment in India was given by Pramod Kumar in the case of ITC Filtrona Limited. In the case of make available skill knowledge and India Netherlands Treaty was India IOS Treaty. I don't know whether sir you remember it or not. That
Absolutely,
was
I
the first.
remember it.
That was the first judgment in most favored
Wow.
nation clause under Indian law, which was given by Mr. Pramod Kumar in Calcutta Tribunal.
That was more than 25 years ago.
25 years ago. I remember that.
So kind of.
Because so coming back, Sriram, well, I am not much worried about what international community looks at our judgments, what international judges, I'm not much worried about it. But what I'm worried is lack of consistency on the principles. That is what I'm worried.
Exactly.
Azadi Bacholan gave one ruling. Vodafone gave a 3-member one ruling. Then software is not taxable. Supreme Court accepted it. Then came MF1 clause, which with highest respect, that MF1 clause is one of the not so correct judgments. In fact, in my book, I wrote about 25 pages why MF1 clause judgment is incorrect. Point is that the judgments, principles on which the judgments are standing gets questioned repeatedly, and that is what I'm worried. I'm not worried about what international community talks. But what is more important for me is that there must be certainty on the transaction for the international community. Now, you cannot unsettle the certainty through a certain process, judicial process. That's second. Third one, with highest respect of all the people and highest humility at my disposal, patriotic fervor is very, very important. I am also a true Indian in my life. Nobody can compete with me on my patriotism, on Indianism. But is that the only reason to impose a tax? That's something which we need to think about it. The tax can be imposed only on the patriotic fervor, or it should be based upon the principles of law. I am not questioning the right to tax by India. India has got all the right to tax. Sovereignty to tax is utmost important. But to tax a transaction, there must be a law for that. And that is what is missing in this case. So while I am not worried about what international community talks about it, but I am worried only as a consistency to be followed in the judgment. The principles have to be consistent. That's all my limited points for you.
Sure.
Absolutely. We are on the same page.
Thanks, Shikhar. So what is the way forward for the taxpayer now, Shikhar, with respect to this judgment? What do you think are the options available? And then I'll come to you with the same question, Pramod sir, once Shikhar gives his view.
For me, the options are three. First option is, which you and I are working, where we need to give a representative to the Ministry of Finance on the impact of Tiger Global on the day-to-day tax administration, which we need to do that, and we need to pursue that, we need to follow that. That's something we need to do. Second, I hope the press release, what was given by the finance minister after Tiger Global ruling, will get followed with the instruction, detailed instruction to the by the board to the members. Otherwise, it will lead to chaos. All the disputes will get into it. Third one, though, I would like to follow Mr. Pramod Kumar's advice on mutual agreement proceedings. But to what extent the policymakers will get into MAP to resolve this sort of tax residency dispute is something I do not know, because there is long back I read it in a US and Germany map on the residency, because under the treaty law, if you are not a resident of either country, then you can invoke map and determine which country you are a resident. It took almost 6 years for the US and Germany to determine which country the taxpayer is a resident. Now, if I go to the map, the time that is taking for process is much higher. Normally, in our experience, I'm not saying I'm an expert on that, but normally in the experience, the transfer pricing disputes are sufficient enough for mutual agreement proceeding resolution. In fact, long back in 99, I went for a map on one particular case on royalty and FTS. Whether it is a royalty or FTS, we went for a map. The Indian Competent Authority at that point of time said that Shekhar, don't come to map for, informally he told me, not formally, don't come to map for royalty or FTS, because in a map it is give and take. In a royalty FTS, there's no question of give and take. Either it is taxable or non-taxable. It will not have any conclusion. So the challenge arises is that while map is a great process, to what extent the map process will be effective is a matter of an issue, Sriram. If we need to go for a map, then we need a stronger guidelines for map on this process. And that is another challenge, Sriram. So yes, if you ask me the question, these are all the challenges. As I said, I've been practicing income tax for the last 40 years. And all the further we've seen more challenges and we are overcoming every challenges. And this is one challenge which we need to overcome in the days to come, Sriram.
Yeah. Pramod sir, your views on the way forward?
I don't think there's a reason to panic. These things do happen once in a while after every 10, 15 years. You get these kind of judgments and then you see the debates, things slow down. And secondly, have faith in policymakers. As a matter of fact, if you really ask me, I would wait till I hear a senior policymaker or a policymaker's call on this. Because I know for sure that their views are not exactly the same as of some legal team members which are heard in public. So what's coming in public is a kind of a view which is to celebrate a winning position, talk about what has been happened, but we are yet to hear the policymaker perspective. I'm particularly confident that on grandfathering, they will have a far more pragmatic approach. Secondly, no reason to panic also for the reason that these judgments, I gave you the example of the judgment virtual soft systems where within 1.5 years it was reversed. And there's nothing wrong in this. We all take decisions which we consider necessary to review after some time. Right now, what is needed is to consolidate your position, to examine it clinically, examine it without emotions, be as clinical in approach as is possible, and try to build a case about what needs to be done. And I have immense faith in the judicial system. I have seen judges, same judge, if after some time they take a different view and they are honest enough to say that no, this perspective you are not aware of. And please don't expect a constitutional court to know about nuance of everything that they have to deal with. The sheer variety of law that they are dealing with is so huge, is so immense that it's quite possible that these kind of things happen. I've not given up my hope. On substance, I think not only that you have to think from substance in terms of the entities, you have to look at substance from a different perspective. Substance from the perspective of jurisdiction. Take, for example, the way business takes place in New York and the way the business takes place in Bombay. So sometimes just because you're in New York, you may not have as many employees, but you have more. Still have substance, which could be jurisdictional substance. Say, take Dubai for example now. The way business is moving in Dubai, kind of volume you are doing. So I think perspectives need to change. Issues are identified. Matters will get debated in the courts. I don't think everything is lost. Yes, as Shekhar said, last 43, 44 years have kept him busy, doing this firefighting. So you are sure that we and our next generations also will have enough to firefight.
I think that's a very good summary, Pramod, in terms of, these judgments will evolve.
And one more thing, Sriram, I just want to tell you, there are cases where in the past the board policymakers have clarified the circular when the judgment, though it may be in favor of the revenue, but a judgment has got a practical issues, the board has clarified in the past. So as long as we are confident, see, it should not appear, let me be very honest, based upon my, you have been working with me from the chamber on various policy matters. If you are going for a benefit of a taxpayer, the policymaker will not agree. The policymaker will agree how this judgment impacting the class of taxpayers. What is the impact? If you're able to demonstrate, policymakers agree. And that's what happened in safe harbor provisions, which you and I worked. That's what happened in various other matters for TDS rationalization. So I am confident the policymakers will give a rationalized view, but it is for us to demonstrate the irrationality behind this judgment if it gets implemented by the authorities in a haphazard manner. That is what we need to put it through.
Sure. I think I would entirely agree with you on that point. The way you see even the developments in the budget, the safe harbor thing, the decriminalization part. One of the biggest strengths of this tax administration is that they have their ears to the ground and they are ready to take. They have the guts to take any decision which is required to be taken. So I for one have faith in the system, and I'm sure that this problem will also find a solution from the system.
Absolutely. And I'm confident we need to work towards a issue solution by which broad-basing the approach rather than this impacts A, B, C, D that puts a lot of stress on documentation. Board will not, policymakers will not accept. We need to go with a bigger picture and a wider picture, Sri.
No, absolutely, Shekhar. After having worked on the transfer pricing and safe harbor and the way the policymakers have listened to the industry over a period of time on both on TDS as well as other measures on ease of doing business, we will definitely do our bit from the chamber on
Absolutely.
on multiple aspects, how it is likely to have impact on the operationalizing some of the treaty benefits passing on to the other party and what is a remedy that we can look for. Right.
Okay, Sriram, I just take a liberty through this webinar. If people who are listening to this call, if you have got any views on the points that need to be represented to the Ministry of Finance on Tiger Global, please feel free to share it to the chamber, because Sriram and team are working on the representation which we are planning to take it to the Ministry of Finance early next week, because that's what the date we are committed. So if anybody has got any views on the challenges on application of Tiger Global, please feel free to send it to Sriram.
Sure. Also, if you have any queries, you put it on a chat window. I'll pick it up and ask to Shekhar sir as well as
some queries have come.
I was looking at it, sir. There's a query from Mr. Ravichandar. What will be the impact of the judgment on FDIs and FIIs investment in India? What's your view on that?
Okay, my view is that, let me be very honest, because 20 years back, all the FDIs and FIIs are interested in investing in India for tax reasons. Now, nobody is investing in India for tax reasons. People are investing in India for the economic benefit, what they get it across. So I don't think, I am not a one person who follows the bogey that this judgment is going to impact the global investment in India. No. Sriram, as you and I know, every global companies, if this is what they issue, I will add up a little bit of cost of my investment. Exactly. I'll come to India because my cost will get recovered over a period of time. So I don't think this is going to impact the global investment, except it is people may talk in the forum, but to my mind, no.
No, I would.
He should ask himself now. He should ask himself whether
we know how to factor the risk.
Because it's taxable.
Yeah. And absolutely, the models will just price for the risk and the models will still run. I completely agree with you, Shekhar, that people come for
the larger question is that the kind of credibility we have as a jurisdiction, that credibility sometimes gets discussed, but then as Shekhar said very rightly, we are not really bothered about what people say about it. We are really bothered about what is the right thing which needs to be done, and it should be done. And one more thing which I must point out, because paucity of time, we did not discuss it. Article 13 part, the capital gain mechanics. But let me tell you, that is the weakest part of the judgment.
Yeah.
If somebody thinks that that's the weakest part of the judgment is that it will be taxable. But that's a different issue altogether. We have paucity of time, couldn't discuss it. And one question from Mr. Ramchandra is, which other DTA could be affected? The effect has already come, I think, on Singapore.
Yeah. Singapore, your UAE will also be impacting.
On the substance factor?
On the liability tax and subject to tax for the individuals, it will have an impact.
Not paying tax.
One thing we have to bear in mind, and that's something which is urgent. What you have to bear in mind is the problem will really be after the 2025 Act comes into force.
Yeah.
Because unlike in the old Act, where the definition given in the Income Tax Act could only be taken to the treaty by virtue of Article 3(2), which required contextual part, in the new Act, because of Section 159, subsection 7, it automatically gets imported there. So that is a worrying part. If Section 229A automatically gets imported into treaties by virtue of Section 159(7), then you have a real problem in your hand. And that's what needs to be addressed.
Yeah, there's another point from Rohinton, what I said, that MAP is normally a compromise rather than a judicial or a technical resolution. Yes, that's what our view also, Rohinton, that for the test of residency, to what extent the MAP will offer a solution is a challenge. But that's what I gave an example of USA and German case where it took 7 years for them to resolve it. In lighter vein, in MFN, they did not issue the circular, and on Tiger Global, they did not withdraw the circular. Yes, you are right. We need to wait for that, Rohinton.
Okay, Rohinton, when you talk about the compromise and judicial resolution, I think this issue is so fundamental in the grandfathering part that I don't think privately, what I understand from the private conversation, no IRS also defends it. And that's the reason sometimes I think that we should use the retired IRS officer into the legal teams more actively. And, as the decision makers rather than those who are briefing it. So today, one good thing which I have seen in the last 3 decades is the kind of people you meet in the IRS. They are such learned people. Their knowledge of professional understanding is par excellence. I think time has come that they have to play a role in the dispute redressal mechanism in the high courts and Supreme Courts in an aggressive way. Government should find a way in which they can be involved with dignity, not taking the senior standing counsels, but they have to invent some way in which they, with due dignity, keeping their earlier status, they can be involved more aggressively. And I tell you, this will bring amazing changes in the way dispute resolution is done by the judicial forums. Trust me for this.
Sriram, the last point from Pranita on indirect transfers, conclusion of that's what Pramod Kumar said, and I also have a view that the Supreme Court conclusion on indirect transfer under Article 13. I'm not saying it is correct or incorrect. We are not in agreement. I am not in agreement with that view. That's all. I would not like to call correct or incorrect. I am not in agreement with the view. That's all I would like to put it across, Pranit.
But there's the point which is made by Pranita. I think that's a very interesting point, because there is a problem with seeking protection in the exclusion clause embedded in 13.3a, because 13.3a talks about share in a company which is resident of the other contracting state, and it was very easy for the ASG and for everybody in the his team to say that, look, here is a company, here is a share which is not a share in the company which is resident of the contracting state. But then I ask you the question, if you don't bring in the deeming fiction embedded in explanation 5 to section 911 to section 13.3a, where else can you bring it? And then because of the residuary clause, it will not be taxable anyway. So to my mind, the taxpayer gave a kind of concession and a very liberal interpretation, where taxpayer on his own included the deeming fiction embedded in explanation 5 to the fiction in 13.3a. But assuming it is not covered by 13.3a, then what's the logical consequence? Logical consequence is gets into 13.4.
You cannot say, gets into 13.4, it is not taxable.
The residuary clause. So if you to answer Praneet's question, I think I have an alternate interpretation which I find much more convincing, but humbly bow to the law laid down by the honorable courts.
Sriram, anything else, Sriram? Anybody has got questions, Sriram? Your final questions?
So I'm not seeing any other questions on this, Shekhar. Now I would request you and Pramod Kumar sir to give your closing remarks. But like you said, Shekhar, we will work. I'll just request the participants, if anything that needs to be addressed in the representation that we are going to make, please share with the chamber. We'll consider it. We'll include it as part of the representation that we will do. As Shekhar and Pramod Kumar sir both said, we've had success when we have been consistently at it, representing the issue that certain things have been creating. This government has kind of considered it, and the amendments that we have seen in the last 2-3 years are a testimony to the way this government listens. But like Shekhar said, the onus is on us to go back with the industry-wide ramification of some of these issues for us to make our point more in a much more articulated manner. Request you to please contribute towards that. And with it, Pramod Kumar sir, your closing remarks, then we'll go. Then I'll request Shekhar to give his closing remarks to conclude this session.
Oh, thank you, Sriram. Thanks for inviting and thanks for this lovely discussion. See, my concluding remarks will be, number one, no need to panic. At the same time, don't get involved into anything other than a clinical discussion on what the legal position is. The moment we get into the emotional part of discussion, who is Deshbhakt, who is not, how does it make sense? Then all the debates, the entire purpose of the debate is lost. We have to realize what the legal position is, address our concerns, identify our propositions in a clinical manner, and we also have to understand that this judgment is not the end of the world. This judgment is not the end of the road. I have highest respect for whatever Supreme Court holds, but I also have the respect for the institution of review. I also have the respect for the institution of seeking larger benches. I am also alive to the fact that many cases, Minerva Mills, we saw Keshwan and Bharti's, how things evolved. We have seen how things evolved in McDowell. We have seen how things evolved in endless other number of cases. So there's no need to get panicky. This too shall pass. Take it easy and confine yourself to the core issues. and keep the government and policymakers in the loop. Address your concerns to the policymakers. And this is exactly what you are doing, and I must compliment you for what you're doing. And I wish you all the very best in what you are doing in keeping the policymaker abreast about your perspective, your concerns. That's it.
Thank you, sir. Thanks for that. Shekhar, your closing remarks, sir.
Well, I'll not get panicky on this judgment because it's a very interesting one if you come across Sriram. 1.5 years back, Supreme Court said in the case of telecom license fee, it is neither capital expenditure nor a revenue expenditure. And it's not a deferred revenue expenditure also when the argument was pressed. Within 1 year, in the case of non-compete fee, Supreme Court took a view, it is a revenue expenditure. When there's an alternative plea was placed that non-compete fee can be amortized over a period of time, Supreme Court said it is a revenue expenditure. So on a simple capital and revenue expenditure, even after 65 years, we're still having a debate on capital and revenue expenditure. So definitely this sort of a debates is bound to occur for a long period of time. So I'm not much worried about this sort of debates. Raises our intellectual ability also. That's number one. So I'm not much concerned about the judgment. As I said, I'm only concerned about the basis on which it has come, and it should not give any tool for the low-level officers to start issuing notices left, right, etc., which will create endless litigation. That is what my only worry. And to that extent, we need to, as you rightly said, we need to go to the policymakers, narrow down the principles of tiger globing and make sure that the genuine taxpayers are not impacted. Third is that it's time for the companies and taxpayers and tax advisors to look at the intermediary company structure. Now, globally, world over, these intermediary structures are not being accepted. And globally, world over, all the treaties have got the LOB clause and principal purpose test. So it's time for us to think that it's time to enhance the substance in all the intermediary companies rather than going into a adventure. I will not call aggressive, I will call adventuristic tax planning. That is what I would like to put it across, Sriram. As far as the existing Mauritius companies, if you still have a Mauritius companies, now this ruling has opened your eyes. Please enhance the substance so that you get this benefit of treaty law. That's all I would like to put it, Sriram. So I would like to put from admin perspective, I like to put a policy maker, and I like to put a futuristic perspective.
Sriram, just one small point, which I think I should have made, but can I have another 1 minute?
Yes,
please,
sir. Please, sir. Please, sir. Final word is yours, sir. Because
no final word. Having discussed all these things about the technicalities of this judgment, one thing we have to bear in mind, the era of those contrived tax shelters is over. And if somebody is looking for the kind of tax shelters which were going on 20 years ago, 10 years ago, one has to reconcile to the reality. When I was discussing this, I was on the case-specific issue on the grandfathering. And I was talking about the incorrectness or correctness of the grandfathering part. That's number one. So by no means I'm suggesting that these kind of contrived structures will work. No longer, phase is over. We are only talking about the specific case where grandfathering was wrongly declined. Second thing is we often get upset about the problems we face. That reminds me of a story. There was one gentleman called Mr. Prakash Krishnan. He was an ICS officer, and he has written a book which I read when I was in Standard 12. That was way back in 77. So, and that book was called A Bureaucrat's Diary. He has mentioned an anecdote in that, and the anecdote is this. He said when he was a child and he used to go to school, must be pre-independence days, the teacher used to ask a question. The question was something like this, that if water is coming from the tap at the rate of X liters per minute, and there are 5 holes in the bucket, because of which water is flowing out of the bucket at the rate of Y liters per minute, how long will it take for bucket to fill in? And he said, I used to wonder, why do they ask me such stupid questions? Why can't they plug the holes first and fill the bucket later? And what he wrote next is something unforgettable, and that's a lesson to all of us. He said, it took me 40 years of public service to realize that these holes will never be plugged, yet we have to fill the bucket. And that's the challenge of life. So we'll continue to have these problems, yet we have to go on with our work, and you have to be ready with it. There will be problems. These problems are not the end of the world. work goes on. That's the short point I wanted to make. Thank you.
Sure. Thank you, sir. That's a good note, good positive note to end the discussion. It's been a fantastic discussion for the last 90 minutes. Thank you so much, Pramod sir, for taking your time out. And I know you were not keeping well yesterday, and you still made it to the session and gave your and the way you explained grandfathering, the history of grandfathering is something that's really fantastic, going beyond the tax laws. And Shekhar, as always, thank you so much for pushing us to do this session on such an important topic. Thanks, everyone. Thanks to all the participants as well. Thank you.
Thanks, sir.
Thank you so much. It was a
Yeah.
pleasure to be with you.
Thanks.
Thank you.
Pleasure, sir. Pleasure is always ours, sir. Thank you, sir.
Thank you
While
very
not
much.
only appearing is left. Okay.